And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question.
You're putting.
Why are you putting in the first place?
Yeah. You're first person. Putting all over. You can put it there. And put it all over.
Really went to law school, and that is.
Yeah.
I know.
Yes.
See, Yona, we have our own legal theory. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that there was the police station and the deputy was in command.
A question. Any other type that you might ask, it's not there, save for the OB extracts.
Just don't go.
Yes, Your Honor.
It is at paragraph 6D. On the 7th of June, the DCI team went to Linda Center in Homa Bay County and arrested the deceased at around 2:30 p.m. And they took him to Mawengo Police Station, placed him in custody with the OB number 10/7/6, 2025. That is 10/7/6, 2025. Then at around 3:54 p.m., the deceased was booked out under OB number 11/7/6, 2025, and escorted to Nairobi, where he was booked at Central Police Station under OB 136/7/6/2025 at 9:32 p.m. Your Honor, we have annexed to paragraph 6A the OB extract, that is AJ1, indicating the time that the deceased was booked at Central Police Station. Paragraph 7, Your Honor, the respondent was arrested. And this is something that would wish the court to take notice. The respondent was arrested on the 13th June 2025 at 18:05 hours, that is 6:05, which was on a Friday. The respondent in paragraph 8 was informed of the reasons of the arrest and for which the reasons and of the offense that is being investigated. That is under paragraph 8. Your Honor, in paragraph 10, now we are coming to the reasons why we want to continue holding the respondent. The respondent is the custodian of the station records, being an OCS, officer commanding station, and the surveillance system, the CCTV. And this is at the material time under the investigations.
You know, still I'm asking, what will be the deponent in sharing this?
Your Honor,
the information the DPP is giving, it is not them who depend. It is the one who depend who should be giving us those paragraphs.
We can talk about it because the
Then
matter
the
is here.
DPP can trace their submissions based on that. Right now, the DPP is turning himself into a witness. And we cannot cross-examine the DPP. It is fair and just. The witness who deponed takes us through his affidavit.
Your Honor, as I said that I'll only highlight a few paragraphs which I wanted the court to take note of. Because, yes. Yes. The defense, yes. Yes. No.
You can hit these ones.
No, Your Honor, I'm only highlighting some paragraphs. I'm not going through the whole affidavit because they have already indicated that they want the deponent on the dock for cross-examination. Yes. Your Honor, what we are... Yes, the CCTV, yes, we said paragraph 10, the respondent is the custodian of the station records and the surveillance system, that is the CCTV, that is under investigation. Yes, investigations reveal that under paragraph 11, that the respondent, together with others who are not before court, hired a technician to interfere with the CCTV system at the Central Police Station in a bid to tamper and interfere with the subsequent investigations. Your Honor, we are highlighting what so far we have done insofar as investigations are undergoing. So there is still some investigations which we need, and that is the reason why we are asking for continuing detainment of the respondent, because the respondent's mobile phone has been detained. And it is subject to investigations. Your Honor, there are also witnesses who are yet to be investigated and statements taken from them. Also witnesses, police officers who are on duty at Central Police Station on that night. Your Honor, given that the respondent is the OCS, we are saying that there is a likelihood that he may interfere with the investigations. Your Honor, we'll be seeking the 21 days.
I had forgotten to hit on that issue about be allowed warrants to access their phone. You've mentioned it, but please just hit it. In addition to the 21 days, we're also seeking an order to access the phones.
To continue holding the respondent. And in addition to the 21 days, Your Honor, we'll be seeking an order that we access the phones.
Number 18. 17 and 18.
Of potential witnesses, the police officers who are on duty, and any other person who was at the vicinity at Central Police Station. And this, Your Honor, we are relying upon paragraph 17 and 18, where we have shown in the paragraphs, we have demonstrated that there is already interference, which has already been done. With that, Your Honor, we will be inviting the deponent to the dock for the cross-examination.
You can testify for the ease of
Yes.
It's comfortable there where is Your Honor, will be seeking that these are standing to an opening statement. They will be allowed to put at 3 minutes opening statement. But,
Yes.
Yes, please.
Bismillahirrahmanirrahim. I swear by the name of the Almighty God, that the evidence I shall give before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God. Your Honor, I am Abdurrahman Jibril. Jibril for you, J-I-B-R-I-L. I'm a Senior Assistant Director, Investigations with the Independent Police and Oversight Authority.
Yes.
Yes, Your Honor.
Let's kindly proceed with the affidavit. There will be questions from the defense.
Thank you, Your Honor. Your Honor, I am one of the investigating officers in the ongoing investigations that IPOA is currently conducting in regards to the brutal murder of Albert Omondi Ojwang. This is pursuant to Section 6, 7, and 25 of the IPOA Act. Your Honor, on 8th day of June 2025, IPOA learned the death of Albert Ojwang while in police custody at Central Police Station within Nairobi County. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Your Honor, all that the witness is saying has been said. He can only adopt. Let me proceed. Because unless there's any other crucial information.
That's another, Your Honor. That's okay.
Yes.
Okay. Yes.
Yes.
Yeah, that's actually in order. They can proceed to examine on the affidavit.
Thank you. Your Honor, I'll be asking the witness, Mr. Jibril. Three. Me, what? Kangai. Yes, we'll cross-examine him. The others will submit. Thank you. Mr. Jibril,
Yes, Your Honor.
kindly confirm your position at IPOA over this matter.
You're asking my rank?
Yes. That's a matter.
Your Honor, as indicated, I'm a senior assistant director in investigations.
And confirm that you are an investigator.
Yes, Your Honor.
Are you an investigator in the purpose and the name or position of the National Police Act?
IPO Act.
Under IPOA Act. And under IPOA Act, is it true that you have still arrested powers?
Yes.
Under which section?
Your Honor, Section 7 of the IPO Act and Section 7 of the IPO Regulation Act actually gives me the powers, privileges, and immunities of a police officer.
So Section 7. And which section?
Both Section 7 in the IPO Act and Section 7 of the IPO Regulations Act.
Gives you the powers as that of a police officer.
Yes, Your Honor.
And in this matter, you are now actively participating pursuant to those provisions as an investigator.
Yes, Your Honor.
Thank you. Are you well conversant with the law?
Depends on which area you want to ask.
Are you, you know, some of us went to teach, then we became lawyers. Some people are mad about that. Do you have any legal training?
Yes, yes, I do.
Could you refer the court to your legal training?
I'm an advocate of the High Court of Kenya.
Thank you. You are an advocate of the High Court of Kenya. Look at the Criminal Procedure Code, Section 386, as an advocate of the High Court of Kenya. Could you be given it?
Your Honor, we will have an objection.
I've not asked the question.
We can see. Your Honor,
I've not asked your question.
Your Honor, at least should I be allowed to make the objection?
Of what?
Let me just object, then you
No,
can...
no. You wait until I ask. I've just told to look at it. It might be just to admire it. Allow me to answer.
Your Honor, we'll be requesting the court to just... Yes.
Okay.
That's right. Your Honor, the witness before the dock has come here on the basis of his affidavit on the factual matters. And that explains why the defense requested that my colleague, my learned senior, does not go into the facts. Section 386 of the Criminal Procedure Code, or whatever provision of the law, is a matter of law. And Your Honor, the objection again goes into the earlier intended preliminary objection, which we have had sight of, where the argument, in a sense, is that this matter, now we have had a copy, although it's not filed, this matter should have been the subject of an inquest and not a miscellaneous application. So that because we are alert, the defense should not try through the window to bring in a preliminary objection which they admitted not to have filed. But more importantly, that this is a witness of facts, not a witness of the law. We can deal with the law between the lawyers. Thank you.
Is the law a fact? Is he in a court of law? Yes, he is. Is he an advocate? He knows it. What is it that they are fearing and telling us they're coming through the window? If they come through the window, please respond and throw us out of the house.
There is a submission. I've not asked any question. I've only told him to look at that section.
It's a matter of evidence on the facts. And it's an affidavit for everything. So let's limit it to the facts.
After I've asked the question, then that is when an inference can be done, whether it's a question of law or a question of fact. I've not asked what. I've only told him, look at section 380.
Your Honor, just one more thing. The reason we requested the defense at the very onset to inform us of the paragraphs is that the cross-examination is limited to the contents of the affidavit.
True.
There is no reference to section 386 in the affidavit. They cannot go to it because section 386, which we referred to, there will be no objection from our end. But because affidavits are pleadings of fact, we plead with you to reject the invitation of the witness to look at section 386 or any other provision of the law. Thank you.
Yeah, I just only told him to.
Let's not configure it, yeah? Let's limit it to an affidavit.
Purely, I've not asked any question, Your Honor. If we only had what I've asked him, and I ask a question of law, then the court can stop. Let him have that. Let him look at what I've told him. No.
He will respond.
And that exactly is our objection, that we can't refer to the law. That is, maybe, see, the council is not understanding our objection.
Very well. All right.
Counsel, maybe rather than asking him to look at the law, yeah, why don't you put the questions to him?
Correct.
All right.
Rather than ask him.
Very well. From your affidavit, confirm the place of death of the late.
Central Police Station cells, Your Honor.
Central Police Station cells. From the IPO Act, provide the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. Because you have confirmed the scene of death is at the police cell. Which mandate gives you that power?
Still point of
Let him answer.
When we are still objecting, council is still taking the same view.
yeah.
He came under the act. You know, section in this miscellaneous application, paragraph 3, they must have said under which mandate they are coming before this court. And this is a witness.
This is our witness now.
He's not an advocate. Let him come in front of you. Let him not be given answers.
No, Your Honor. We plead with our colleagues to just remain respectful. We know that they are very good people. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to refer to the law.
Very well.
We do not mind if you read the law to him. Questions.
Read paragraph 3 of your act.
Please read for me what I can answer.
No, you read it. I did write it.
Which one?
Paragraph 3.
That investigations by IPOA are pursuant to section 6A, 7.1 and 25.1 of the IPOA Act.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this affidavit.
That's what I'm saying.
Yes.
You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is you as in your affidavit talked the law. Give me the law that gives you mandate to investigate a person who dies in a police cell. That is simple.
I have indicated the sections 6.1, 7.1
Tell
and
the court.
25.1.
Just
Yes.
tell the court.
Yeah, Honor, I have indicated section 6A, 71 and 25, 1 of the IPO Act.
Could you kindly read to the court those sections that gives you that mandate? The IPO Act, just read to the court those sections for the benefit of the whole world. We don't work for IPO.
Neither do we.
Your Honor, because we did not anticipate that a witness of fact will be made to read the law, we didn't carry a copy of the IPO Act. If they insist that they want to read it, let them just give us the...
Which suffers from selective amnesia when he is cornered. It is on any form. Just read the form. Read the section. 6, you read.
Okay. Section 6, Your Honor talks about functions of the authority.
Yes.
Here means IPOA. That the functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offences committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including recommendations for prosecution, compensation, internal disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where the death of a person in police specifically comes up. My question is specific.
Your Honor,
JV, allow the witness to read.
This is a question.
Sorry, Your Honor.
Before you even say anything, this is a question that has been put to this witness. It is about what he has said in his affidavit. He is being asked to justify why he is here and what gives him the powers. The state, who has not been asked a question, who can now stand and start giving him answers or start supporting him. Let him answer.
Yes. Yes, Your Honor, I just wanted to indicate. Section 6 has been referred to in the affidavit. The witness has been asked to read. He has read the affidavit. The witness is being asked about the law supporting an action which is not in the affidavit. That's where the difference is. The witness is saying that Section 6 allows us to do A, B, C. But counsel is asking, does the law allow you to do A, X, which is not in the affidavit? We believe that by him having cited to us the paragraphs he would ask questions on, asking the witness about the law allowing you to investigate deaths in cell, which we have not referred to in the affidavit, is going outside the affidavit, but we would be guided.
So let him answer. If it falls under the ambit of that section 6, let him just say...
That's right, that's right. That's right, that's right.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If he says that section, then the court will go and make a ruling out of it. That's all we're asking. In relation to death in a police cell.
In police custody.
It's not you to set my question. I've asked you my question. You can't set a question and answer yourself.
Yes.
If it's not there, it's not there.
Do you have the powers to investigate?
Yes. We have powers to investigate death that occurs under police custody.
And that's good enough.
Yes, and custody includes service.
The court has gotten what we have asked. The question has been answered. We'll do submissions on it. That's all. Let's go to paragraph. Paragraph 7. You have paragraph 7?
Yes.
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOA and was later booked at Langata Police Station via OB 50-13-6 of 25 at 18:05 hours.
The DCI officers arrested him at what time, according to your there?
You said around 3.
You read exactly what you're saying.
I've not indicated the time.
That's what I'm asking.
Yes.
It is not indicated when the DCI officers are arrested.
Yes,
Where did they arrest?
at the DCI headquarters.
And not Eldoret.
No, Your Honor.
Found that the accused was not arrested at Eldoret. The respondent.
According to the officers who handed over me to Mr. Talam, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that IPOA released a false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my affidavit.
I'm saying what is in social media is that the respondent...
Your Honor, I can only answer what is in this affidavit.
Sorry, Your Honor.
Let's not digress to those issues.
Yes.
Yes.
Let's proceed on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my affidavit.
That's why I said, are you aware? If you're not aware, you're not aware.
Counsel, please ask me what is in this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside the affidavit.
I put it to you that based on the DCI mentioning the respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, Juan Keton. Were you aware of that?
If you said so.
Thank you. And the DCI authorized his officers together with the advocate to present the respondent to IPOA headquarters.
Your Honor, we have said time and again.
I'm putting it to you.
Please,
You don't need to answer.
please answer me ask me what is in my affidavit. Let's stop charges, Counsel.
Counsel, I've only put it to you, I've not asked you any question.
Is it in my affidavit? The question I'm asking to you is it in my affidavit? The answer is no.
Of the court, I'm putting to you, then I'll ask you where you are saying you are arrested.
Your Honor, I will decline to answer anything which is not in my
I've
affidavit.
not asked. I've not asked.
Then please ask.
I put it to you that the officers handed over the respondent to IPOA in the presence of Mr. Keto. As I put it to you, for the record purposes.
Samson Talam was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, Juan Kiprono. Who is it?
Is that in my affidavit?
I'm putting it to you, counsel. You are a counsel. When it's a question, I'll ask you a question. I'm
Please-
only putting to you
please
for
ask
knowledge
questions.
purposes. So now, if those are the facts, look at the paragraph you said he was arrested. Paragraph 7. Now I'll ask you questions from there. Read.
I have read and read. What is the question, please?
No, cool, it's a long day.
No, it's a long day, yeah? It's okay. It's okay.
When the state is rich, it can bring water.
Yes.
For both of us and the council. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by the DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
No. The fact that he was brought under the escort of DCI officers means he was arrested and brought to IPOA office.
Court has taken that. Let's go further.
Sorry, Your Honor, I think this may be my last objection. We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matters we have is the one given by the witness before.
The only way to prove falsehoods is by bringing facts that are truth. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
So, sorry. You know, I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matters, especially a lawyer or an advocate, from the bar. Right now, we have affidavit evidence given by this officer. We are having an alternative set of facts, which may be true. We have no reason to doubt it. But until we have an affidavit, all that is telling us is, I put it to you. And we hope it does not go to evidence.
Just to allay your opinion.
Yes.
The evidence that I'm mentioning is from you.
That's right. Thank you very much.
Not from Mr. Danson.
Thank you.
Because as we put it right, he's not giving evidence.
I'm not.
He knows the procedure.
Thank
That's
you.
why.
It's a teacher of the law.
Yes,
Thank you.
and that's why I told you, Witty now is mature to be a judge of the high court. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Yes, Your Honor.
Paragraph 9.
Yes.
You have said what about the position of the OCS?
That the respondent at the material time of the incident, he was officer commanding Central Police Station, exercising command of the Central Police Station, hence persons of influence, and has capacity to interfere with the ongoing investigations and likely witness.
Do you have any evidence to show that he was in full command at the police station at that time?
As an OCS, that is...
I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty or in command?
Your Honor, what the advocate is asking is that you are the presiding magistrate here. Do you have the power of this court? I mean, once you are an OCS, you have got the power of another station. Come on, counsel.
We have agreed that you don't have. You are looking for it. Let me put it let me put it to you.
And Your Honor, just to answer also, whatever evidence that I had, I have put as an extra. Anything else which is not here is purposely done to safeguard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be preferred. Yes.
So, and I've asked a simple question.
Yes.
Among the annexures, you produced an annexure showing he was in command of the police station at the time the offense was committed?
I recorded his statement and he confirmed that at the time of the incident he was the officer commanding station at Central Police Station in the presence of his lawyer. I have not attached in this affidavit.
Simple. The answer is clear, you have
Yes.
not attached. All that's what you are looking for. Should not attach there.
And maybe to answer your question, any other attachment that you might ask is not there, save for the OB extracts.
Just don't go. And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question.
You're putting.
Why are you putting in the first place?
Yeah. You're in the first place. He's putting all over. He can put it there. And put it all over.
You really went to law school, and that is.
Yeah.
I know.
Yes.
See, Your Honor, we have our own legal theory. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that the police station and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has had it sorted. Let's go. Paragraph 15. On the question of him likely to plan. You're there?
Yes.
We have agreed there is no any material presented.
Yes, nothing
Thank you.
attached.
Please proceed.
Okay.
Paragraph 10.
We go back.
Oh, I asked you paragraph
15,
15.
yes.
I'm going to paragraph 16, sorry. Still no material attached. It is either very serious material you have kept, no material attached.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18.
No material attached.
No material attached. Paragraph 17.
Come on.
I've gone back because there's a question I want to ask.
Yeah, please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Start on off. Or it is non-operational police station.
That question is not, it's not in my affidavit.
You've run very fast. Do not lie that is. So you cannot, there's no material to show that.
Nothing attached, Your Honor.
Paragraph 19. You've read it?
Yes, Your Honor.
And 21, they are the same?
What's the question? No material attached.
There is no material attached.
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. This is a lawyer. He knows High Court decision.
Court of Appeal decision.
Give the court that decision.
In the Titus Ngamau case, 2020. It was a phrase coined by the judge who was dealing with that matter.
And I remind you, Cliff is the one who argued that matter.
Yes.
He'll face you over that matter.
It's okay.
He's the one who argued that matter. Cliff will deal with the blue code. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 23.
Yes, Your Honor.
What is the reason you want to detain him? In paragraph 23.
That we are yet to record critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required so he doesn't interfere with the witnesses.
About recording statement and interference are two things. Wakili,
I have responded to your question. The reason as to why I'm seeking that prayer is to have him detained so that he doesn't interfere with the witnesses.
Very well. Does he know the witnesses?
Yes. Them being police officers? The answer is yes.
Is there anything you have shown of any attempt to interfere with witnesses? Because counsel, you know very well, the authorities, the Sagari, Duarte Sagari, Cliff will ask you. The questions I'm asking is to prove, have you demonstrated by material your varmint?
Nothing attached.
Thank you. The court has come. Paragraph 24. What are you addressing?
That we are saying if released, his security is not guaranteed due to the public anger demonstrated by the case.
Okay.
I've just read what is in the affidavit. I'm saying that the gruesome murder of the deceased has elicited widespread public anger. And therefore, if released at this point, the respondent's security cannot be guaranteed.
Mr. Witty took us a lot about the case of Oscar Sudi. Heavily. Have you ever had a chance to read paragraph 32 of that decision of Professor Justice Joel Ngugi?
Not in my affidavit.
It's not in your affidavit.
Yes.
For the benefit of doubt, you are saying you want to detain him on two limbs. One, for the safety of his life. True?
Yes.
Do you have anything to show that his life is in danger?
Nothing attached.
Do you have anything to show that he is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Lawyers are swear to be court officers. It is an apprehension. And you are very aware that the National Police Service is the one mandated to provide security for everybody in this country, including the already convicted murderers. You are aware of that?
Not in my affidavit.
No. You will feign to be not understanding what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And this country is not a banana country where the rule of law has broken. So it is not right to say you are preserving his life in cell. And he pays taxes. Everybody pays taxes to be protected. And that it will be dealt with in the cases that I've talked about. Now, what other reason do you need him in cell to detain him for 21 days?
All I stated
what do you specifically want him to do?
All I've stated in my affidavit.
Is there any other reason we have not dealt with?
Everything I require, I have indicated in my affidavit.
Confirm you have his phones.
His phone.
His phone, you have it.
Yes.
And you are seeking this court. Did you have the court order to possess that phone?
I don't need a court order to possess a phone.
Do you need a court order to get access to the phone?
Yes, I do.
Where is the provision that does not allow you to have authority to possess?
It's a seizure.
Sure.
Oh, wait,
Sorry, no. Yona, where is the provision that does not allow you? Surely.
Where is
you
the
are
provision?
asking for a provision which does not allow you. This is a negative provision, does not exist in our law. He should tell us the positive provision. And council can put it, he can continue putting it to him, that this provision does not allow you, not the negative provision.
I'm rephrasing. You know, which has a problem is preparing for the judgeship. He's not keen to this matter. You need him 21 days for the sole purpose of granting access. Is it him who grants access or the court?
No, Your Honor.
Who grants?
I need the 21 days to complete my investigations.
I've asked a question specifically. Do you need my client in cells for the purpose of analyzing the phone?
I need your client in custody for 21 days to complete my investigations.
I've asked a simple question. Is there any role he's required to do in forensic analysis of our phone?
I'm not an expert in forensic analysis, so I cannot say.
So, your varmints are not based on any scientific, because you never consulted a forensic expert? It is you swearing 21 days.
Yes.
And I've asked you, show the court why 21 days. Why do you need him specifically?
Your Honor, the issue is not about only phone extraction. It's not only about phone analysis.
What else?
I have said to complete my entire investigations that entail so many things. Among them, what you have stated.
And lastly, you have already attached the order in your application. Look at it. We have an order. True. Makori, this is a competent advocate and witness.
No,
I have seen an annexure here.
Can I check, yes?
I've seen an annexure there. We were given an annexure that has. Is it yours?
Yes.
Or it is audit?
No, it's ours.
Very well. Let me ask you the question. You are certain you are getting
It's a draft.
these orders?
Council, this is
No.
a draft.
No.
It's a draft.
Which is saying, is the office of the DPP or IPOA that gives the orders, or is the landed court? What is the import of you drafting an order? Is it a formality that in this court already you have decided, not the court itself? Who decides? I hope it ceases from being
I hope
the norm.
we can save time by admitting that the application was drawn by the office of the DPP. What we have annexed as an order is a draft order. It is not the first time today, is it 18? It has been done since I was a law student at the University of Nairobi, where we do draft orders. The court can reject it, it's not binding on the court. So that we save time for counsel and his client.
We have only for good practice.
We admit.
Avoid doing the judicial work. Leave the courts to do their works.
I think what Mr. Wiki is saying is just a practice that they have adopted from the DPP's end, which is not a good practice.
It is not good practice.
So let's leave it at that.
If I sat in that office, I wouldn't allow that. But I was chased. Thank you very much. Let me allow Mr. Kangai to proceed. Oh, sorry, Your Honor, I said if an advocate is not allowed to talk, I will be stoned out. Put Mr. Shadrach on board. He has just left class to come out. He was teaching in his lane on the forum.
It's up for them.
They will release Shadrach.
We're just trying to put in order. It shouldn't be a difficult one. After Mr. Shadrach, Mr. Keton would lay his legal basis. Then I'll wrap with the application. I think Mr. Umbeta and Mr. Njui will be making a submission on that.
Your Honor, with your permission, I will ask very few questions to my colleague, Mr. Jibril. Unlike my seniors, I am the soft one.
And I hope you are around so that you don't ask again the same questions which I have already answered.
Yes, I teach law, just relax.
Yes. Save on time.
The problem is this body. Cliff, make sure he eats well.
Thank you. Thank you. Mr. Jibril, I want you to confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Wang is the Deputy DIG Edwin Lagat.
Please repeat the question.
I want you to confirm to the Honorable Court that the late Albert Ojwang was arrested pursuant to a complaint made by the DIG, Mr. Eliud Lagat?
Yes, Your Honor.
Thank you. You also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Eliud Lagat. Is that correct?
Yes, Your Honor.
Thank you. You confirm to the court that the investigations you seek time to continue with are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct?
Yes, Your Honor.
Thank you. Please inform Your Honor the name of the chairperson of the body where you are coming from.
Your Honor, I think we have agreed that what I'm going to answer is what is in my avowment.
Please, just listen.
No.
This is cross-examination.
I decline to answer that question, Your Honor. It is in public domain who is the head of IPOA.
Just respond. That is your work here.
I'm responding.
Please respond. Who is the chairperson of IPOA? That is your work.
My response is it is not in my affidavit.
Yes. JV, just inform me.
No. Your Honor, we have agreed that I will be cross-examined on what is in this avowment. The chairman of Independent Policing Oversight Authority's name or his position is not in my affidavit. Yes. And the council knows who is the chair of the IPOA.
I don't know. Please answer the question. Who is the head of the body where you hail from?
We don't have a head. IPOA does not have a head.
So who is the chair of the IPOA?
Yes, that should be a right question. The chair of IPOA is one Ahmed Hassan Isaac.
Thank you. Now, you confirm to Your Honor that there was a joint press conference on the 9th day of June 2025. Is that correct?
Your Honor,
No,
I'm not going to answer anything outside my affidavit.
Your Honor, if you permit me, just to also give context why I am asking this question. Your Honor, my learned senior and friend, Mr. J.V. Owiti, went to a very large extent in explaining the authority that was made by my Lord Professor Joel Ngugi in the Oscar Sudi case. Some of the parameters that were set by the Honorable Court were two. I think that is paragraph 24 of that authority. On the question about bad faith, the question about exceptional circumstances, and lastly, the balance of the quadruple rights that the court should look at. One of the items that we have a duty and responsibility to prove to you is to demonstrate to you that indeed there is an element of bad faith in the application that has been made before you. And that is why my questions are aimed at eliciting some of these facts based on the evidence that is going to present before you. So, Your Honor, I plead with humility that counsel, my colleague, I even suppose he's my senior. My senior should just
I'm not
be
your senior.
kind enough to
I'm not your
respond.
senior.
Yes, looks are deceitful, but...
Your Honor. Yes. Yes. Your Honor.
You cannot argue the court.
No. Order. Chair. Let me say this. Let me say this for the record. No, let me say it for the record. And Your Honor, protect me. The counsel who is on the floor asking questions should only answer. Learned senior should stop pointing at me. You will have your time to ask me questions if you require. The second, Your Honor, the second point I'm making here is that anything outside this affidavit, whether our chair is not within my knowledge, and please stop asking me. Anything outside this, I'm not ready to answer. It's not within my knowledge and belief.
What is the basis of what happens to your ruling?
And after all, Your Honor, the application we are making is about an extension of continued detention of the suspect. It's not about what happened on the backyard. What you are pointing is bad faith.
Just say you are not aware. If they ask you about stock, I am
You can just give us a minute. And 1 minute. No. We don't need a break. I think just
No, we don't need a break. We don't need a break.
just 1 minute.
You're not aware. That is what they want.
You know, I cannot say I'm not aware. Of course.
Who is the chairperson?
That is what they are doing.
Skia. It's not our intention of making you mad. If you're asked who the chairperson is, just answer. If we see them causing the life,
We will
first
intervene.
okay, we will intervene. So don't let us lose that hope. Okay. Yes, that's what they're drinking. Okay.
We are not lying. Listen, calm down.
So calm down. Just answer what you Yona, thank you.
Thank you. I know better.
Wakiput, it's theirs to put.
Yes.
When they are putting, it is theirs to put. You are not aware.
Thank you. Thank you. Mr. Jibril.
Yes.
Counsel, please confirm to Your Honor that there was a joint press conference on the 9th day of June 2025, was in the company of Mr. DIG Eliud Lagat and the Inspector General of Police and others.
I'm not aware.
You are not aware. Thank you. So you have not, Your Honor, you have no information that indeed your chairperson held a joint press conference with one of the persons who's been constantly mentioned in the death of the late Albert Ojwang. You have no information, isn't it?
Your Honor, the chair attends several press conferences.
Leave those several.
So I don't follow the chair.
Thank you.
I don't follow the chair for his press conferences.
Thank you. Now, Your Honor, that is very important. You have been very honest with the court. Now, I want to return to paragraph 27 of your affidavit. Yes, paragraph 27. You have made mention that the reason why you are inviting the court to order the pre-charge detention of the suspect before court is because you have fear that he might run away from the jurisdiction of this court, isn't it?
Yes.
Have you, in your well-elaborate affidavit, demonstrated an instance where probably he was invited, he never turned up, or you have proof that he has already booked a ticket to a certain foreign land that you have presented before court?
That is not in my affidavit.
No, you have in your affidavit.
No, I'm saying
yes.
the answers that you're looking for is not in my affidavit.
No, I am asking a very straightforward question likely to attract a yes or no.
Yes.
I am asking you again. In lieu of your paragraph 27, on the question about the temptation by the suspect to run away from the jurisdiction of this court, if allowed his liberty, have you provided before this court
No.
any material?
No.
You don't have any material?
No.
Thank you. Your Honor, that should be all from me. Thank you.
The two. I'm actually going to take very limited time in the form of 2 minutes. 2 minutes. And I can do 1.5 minutes, depending on how it's going to answer the question. Now, Mr. Jibril, I want you to remember the testimony that you've given us just a few minutes ago, where you told us that the scene of crime was processed and released to the relevant authorities. Is that still your stand?
No, it's not in my affidavit. That's my answer.
Asking you,
yes.
You made a representation to this court and told us that the scene of crime was processed and released to the relevant authorities. Is that correct or not correct?
Now, Your Honor, the scene of crime here I'm talking
Is it
about.
correct or not correct?
The cells where the deceased died has been processed and released to the relevant authorities.
Thank you. Now, can you tell us the investigative steps that you have used to preserve the CCTV and the occurrence book?
The occurrence book is a digital. It's not.
It's a digital
It's a digital. Yeah.
Is it with your possession right now?
No, it cannot be.
It cannot be.
It cannot be in my possession.
Have you extracted the relevant entries on that particular day?
Yes, and attached to the affidavit.
Thank you. Now, number 2, about the CCTV. Can you tell us the preservation measures that you've taken to preserve the sanctity of that CCTV footage?
Your Honor, we are a team of investigators. That aspect is being done by the forensic team.
So you can also confirm that the CCTV in itself is not with the police station. It is with the forensic team.
And what was extracted is the only DVR. But the entire, you can't carry a whole screen.
It's okay. That's what I want you to tell me.
Yes. What was extracted is only the DVR.
Yes.
Yes.
So the DVR that records the events of that fateful day is the forensics team.
Yes.
Thank you. That's all you want.
Thank you. Hi, Chief.
Good morning. Good afternoon.
Good afternoon. I can't be allowed to ask you just 2 questions. I want to take you from paragraph 6A. Where you have said that this year received a complaint from the Deputy Inspector General of Police. Confirm?
Yes, Your Honor.
Was it an oral complaint or a written complaint?
It was a letter, a formal.
letter?
Yes, a letter to the DC.
Have you provided that letter to this court?
No, it's not attached here.
It's not attached here?
Yes.
Thank you. Kindly go back again to paragraph 7, where you say the respondent was arrested and under the Langata Police Station, OB number 50.
Yes, yes, Your Honor.
Who booked the respondent at Langata Police Station?
The booking was done by myself.
It was done by yourself?
Yes.
Thank you. Are you aware of the law governing the booking of a person at a police station?
As per the IPO Act, yes.
As per the IPO Act?
Yes, and the regulations.
For instance, are you a police officer? A former police officer?
I'm not a police officer. I'm an IPO employee.
Been a police officer?
Yes, I've been a police officer.
You have been a police officer?
Yes, Your Honor.
Thank you so much. Paragraph 21. Now, paragraph 21, you are saying there are co-conspirators. Confirm?
21, yes.
Do you know the co-conspirators by name?
That is part of investigations. I cannot reveal here.
No, I'm just saying, do you know by name, not their names? Do you know them by name? Because you have said there are co-conspirators. Do you know them? Not by name.
Okay, you don't have to need to name them.
Counsel, this is what I've been saying.
Relax, Jibril.
Let me answer her. The thing is,
Let me help you.
yes.
Just say yes or no. Do you know the co-conspirators?
The matter is under investigations.
Yes or no?
As of now, no.
You don't know them. Thank you so much. Number 25. You have said that there was the murder of the deceased was planned, executed, and their attempts to cover up. Do you know the people who are trying to cover up the death of the deceased?
One of them is your client.
Do you know that with certainty?
Yes.
Have you provided evidence to that effect? Or
No.
the attempt to cover up?
It's under investigation, but not attached to this affidavit.
You have said that yes, you know the client is one of the people trying to cover up. My question is, have you provided evidence that he is one of the people who is trying to cover
As of
up?
now, no.
No.
Yes.
Thank you so much. Thank you, Honor. That is
I think, Your Honor, that will be the end of the determination of the witness.
We will lay now, if it is, once it's discharged, Mr. Kiton will lay the basis for our next line of approach.
Your Honor, we would learn a few minutes of re-exam because
that follows cross-examination. Mr. Jibril,
Yes, Your Honor.
my work is to calm you down completely and make you
No, actually, I'm calm and composed.
I'm glad. Thank you. Now, I will limit my questions back to the contents of your affidavit, many times by paraphrasing.
Okay.
What is the basis of your request for detention continuing in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now, on a scale of 0 to 100%? It doesn't have to be accurate, approximation.
49%.
49%. So I can mathematically say this as direct evidence that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in charge of, who is in command of the station. Do those questions relate to the remainder of your investigations?
Yes, they do.
Now, to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to Mr. Johnson.
Just one question in the examination. You have been asked whether you have attached any document relating to.
Yes, Your Honor. The reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the investigations. And this is actually to protect the integrity of the investigations. That's why we cannot divulge much.
Thank you very much. I believe that is all from my end.
Thank you, Your Honor. Yes.
We're going to allow the next phase of our team, led by Kito. Now we consider check out as we are ready, we are already asking for the benefit of 4. There's Kiton, there's Lamat, there's Lucy.
We are fine. We are fine. The only thing that we'll be asking is there something that has been filed so that it can be served? Or it's an oral? Yes, very well.
We'll serve you with authorities, simply. Can our team serve the state of the law? You are there?
Your Honor, for the record, I remain Felix Kiton, and also there's also another additional attorney at law, Vincent Yegon, also is part of the defense team.
Present, Your Honor.
Your Honor, we reiterate that we vehemently oppose the motion application dated the 16th of June 2025. And from this motion, Your Honor, there is only one salient issue for determination. That is whether there are compelling reasons for continued detention of the respondent. Your Honor, permit me latitude to lay the legal basis. It is our humble submission, Your Honor, that the issue or the question of pre-plea, pre-trial, or pre-charge detention has been settled in law, is well settled in law. And as such, Your Honor, Article 49(1)H and 49(1)G of the Constitution is very clear that an arrested person has a right to be released on bond or bail unless there are compelling reasons. Your Honor, in order to conceptualize and also problematize the issue, Your Honor, permit me to refer you to the statute, which is Section 36A of the CPC, of the Criminal Procedure Code. And in order also to contextualize the issue, Your Honor, is that this Section 36A was an amendment following the locus classicus in Michael Rotich, that is in Michael Rotich versus Republic, the 2016 decision, whereby, Your Honor, in this section, it lays the two-tier threshold for such an application to succeed. The first burden, Your Honor, is on the investigation, that is the IPOA. And the other also burden also, Your Honor, rests with the Honorable Court. And as such, Your Honor, under Section 36A, it is very clear that pursuant to Article 49(1)F and G of the Constitution, a police officer shall present a person who has been arrested in court within 24 hours after being arrested. And now it lays now what the investigation officer must do. First, he must make an application in writing. First, he must produce the suspect in court, which they have done, which we admit that. Then the second thing, Your Honor, is that they must apply in writing. And they have done that through this motion application. But now, Your Honor, the greatest issue that they must also do, Your Honor, is that under Section 36A, clause 3D, it states that the investigation must also adduce the reasons necessitating the continued holding of the suspect in custody. So the question that begs our attention at this juncture, Your Honor, is whether there are reasons necessitating the continued detention of the respondent. And we submit, Your Honor, in negative, that the investigations have not adduced any cogent reasons necessitating continued detention of the respondent. And Your Honor, my learned friend, they have already gone through the cross-examination limb by limb in the entire affidavit. But if you may permit me only to refer you to 2 or 3 salient issues, Your Honor, in order to illuminate why this motion application is bereft of meat and substance to stand on. First, Your Honor, I will refer you, Your Honor, to look at paragraphs 9, 10, 11, and 20 of the affidavit. They are building a case that you should continue detaining the respondent because he's likely to interfere with the investigation. We submit, Your Honor, that that is not a cogent reason. And we'll invite you, Your Honor, to consider the authority which we are provided, that is Republic versus Mercy Chebet. It is a 2022 decision whereby Justice Gigonyo has indicated succinctly, and I will humbly refer you, Your Honor, to paragraphs 17, 18, and 19 of that decision, whereby the High Court has settled the law that for such a threshold to succeed, the investigations must tender material information to the Honorable Court to demonstrate the nexus link that is between the respondent and the likelihood of interference. And I will also refer you, Your Honor, to also adopt the reasoning of Justice Mutuku in Republic versus William Chirchir and Godfrey Kirui, whereby the same threshold.
Your Honor, this is not an objection. It's an humble plea that counsel shares the decision with us, and that it is generous enough that he also points out the paragraph that is paraphrasing, so that we are able to respond to that.
Your Honor, we have already filed our list and digest of authorities dated in 16th of June 2025, and you can confirm, Your Honor, that they are there. The decisions and everything, we have already finished. It's the last decision.
The last one.
Cancel the one which is on the is the one.
Sorry. I am looking at your document, sir. I am alert.
Thank you.
The document written respondents list and digest of authorities.
Yes, Your Honor.
I am looking for Mercy Jebet. Do you have it in the list?
There is another one which is look.
So it's not in the list.
No, it is in. Is the one you are holding.
Thank you.
So
This is the list. It does not have Mercy Jebet. Does it have it?
You already have an authority, the one in next to your phone.
Your Honor, what we are informing the court is that we didn't have it in the list. So if he has added it, that's okay. That's what we're asking.
They
so
have
we
already
can have
have
the
the authority, Your Honor. We have already finished. Yes. 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 And they equally have. Yes. 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 So Your Honor, if I may, it appears there was an oversight, Your Honor, but I know the court takes judicial notice of all the citation, of all the authorities, which we have already provided the citation, Your Honor. Sorry, Your Honor, he has interfered with the flow of my thoughts.
My apologies. My apologies. I am not in that business like my colleagues.
Yes.
The two musketeers.
So what you are saying, Your Honor, at paragraph 17, Justice Gigonyo has laid the threshold and also illuminated that interference with witness undermines the criminal justice system and dents the integrity of the criminal process. And he goes on and also says that for such a ground to succeed, the prosecution must tender or must present material information to the Honorable Court. And the earlier decision which we have also cited, Your Honor, the William Chirchir case, whereby Justice also Mutuku has said that there should be a nexus between the respondent and also the stated interference, Your Honor. So that was the main ground, Your Honor, that has been advanced at paragraphs 9, 10, 11, and 20 of the affidavit. Another link, Your Honor, of the affidavit is that, Your Honor, I will humbly beg to refer you to paragraph 24 of the affidavit, whereby you have been told, Your Honor, that the gruesome murder of the deceased has elicited widespread public anger and outrage leading to demonstrations, which at times have been destructive. Hence, the safety and security of the respondent cannot be at this point be guaranteed if released on bail. So in order, Your Honor, to demonstrate that such a reason, Your Honor, should not hold waters is that we will humbly beg to refer you to the same decision of Justice Gigonyo, that is Republic versus Mercy Jebet, whereby at paragraph 20, which is also titled Safety and Security of the Accused Person, the judge lamented, Your Honor, at paragraph 21, that I have lamented time without number, and again slide into grief. How and why in this age and time should people take the law into their hands to harm the accused. The community herein is within the territorial jurisdiction of the Republic of Kenya, a nation governed by law and order. And under the Constitution of Kenya 2010, I wonder whether the said community will derive the authority to harm or kill a suspect under trial. No one is above the law or should take the law in their hands. All are bound by the Constitution which reigns. And the community in question should let the law punish the accused. This should stop, and my view is that ground that the security of the accused is threatened by the members of the public or victim family should never, and mark my words, Your Honor, should never be encouraged to be a ground for denial of bail. Otherwise, the courts will inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. We say no more, Your Honor. Such ground should fail in limine. The court, the High Court, has settled the law on that. On the other hand, it is even the duty of the police to also guarantee the safety of the respondent. And you have also been told other issues, Your Honor, that they need time to do forensic.
To go political. Your Honor, I'll start with the last point on whether or not an inquest which has been brought through the window is available or is an obligation of this court as suggested. It's something I've written on, so I can quote the one decision on this. Understandably, the decision that Mr. Omari has referred to the court to, if I got him right, is a decision of number 96 of 2011, Your Honor? 93 of 2011. So he's my good friend. He may not have seen what Honorable Justice William Musyoka says in Dennis Rosanna Manyibe. I will give the citation. We didn't know you'd raise the inquest.
We don't raise. So, just give the citation.
Your Honor, Dennis Rosanna Manyibe and 4 others versus ODPP and 2 others. The good judge is not only an authority in law of succession, he delivers a beauty of a judgment. The citation of this case is Kakamega Criminal Revision number E001 of 2022. E001 of 2022. And basically what the judge is doing is the nature of inquests in post-2010 Kenya. And I'll read one paragraph. This is what he says. I quote him, the first is whether it was necessary, which is what Mr. Omari is telling you, in the first place to conduct the inquiry in view of the letter by the first respondent, the ODPP. The purpose of conduct of inquest proceedings is to primarily determine the cause of death, particularly where it is suspected that the same was by hand of another. Where the persons responsible for the death are known, there would be no need to conduct an inquiry. The suspects ought to be arrested and arraigned to answer to a charge of either murder or manslaughter or any other related offense. The inquest would be conducted where there is doubt or where the accusation is clouded in some mystery for the court to unravel the mystery. Where there is no mystery or the circumstances are fairly clear, then the first and second respondents need not ask the court to conduct an inquest. This is part of the law on inquest post-2010. There is a similar decision by J.B. Ojwang. He was a judge by the time. He rose all the way to the Supreme Court. And the decision which I would invite the court to have a look at is Nisha Sapra versus Republic. This is way before the Constitution of Kenya 2010, but it still has the same principle. There's also the decision of Honorable D.S. Majanja J. May the Lord God put his soul in eternal peace. In Re-Estate of Philip Otieno Odhiambo. Re-Estate of Philip Otieno Odhiambo. This is reported in 2015. And finally, on the question of inquests, one of my favorite judges, Justice Mwongo, my phone has just gone off, Your Honor, but I'll provide Justice Mwongo's decision.
Help us more knowledge. You know we are students. In those decisions, where was the scene of the death? Just tell the learned.
All right.
Only that.
Sorry, Your Honor, I will not answer that. Yes. Yes. Thank you very much, Your Honor. I am done with the point. Thank you. Thank you. Thank you, Your Honor. I am well guided. Actually, that's why I started with it first. We are done with the question of the inquest. Now, Your Honor, I wanted to read for you the decision of Titus, the Court of Appeal decision on Titus Ngamau, but because my phone is off, I'll just ask them to get it for me, because I think we need a point of reflection in this matter. With a lot of respect, I think the defense have treated this matter with some lack of seriousness, with a lot of respect. And that's why you hear questions like, release him on a bond of 7,000, release him on free bond. You know, this court is bound by section 60 of the Evidence Act, and this is 60 subsection 1 subsection O, to take judicial notice of matters of public notoriety. Judicial notice of matters of public notoriety. This court is human and does not live in vacuum. This court has eyes. You can see the number of media officers here. You can see the number of Kenyans in court today. This matter cannot be treated with a lack of seriousness. And what is the matter? The matter is that we are saying a Kenyan died in a Kenyan police station. And that Kenyan is identified as Albert Ojwang. You know, of course, we are both Luos, but that's not why I'm making this argument. That is a disclosure of conflict, possible conflict if there was. There is also admission from the defense that the person sitting as the respondent before you is the OCS. While they had questioned it in their affidavit, they have admitted severally. And not just the OCS. He's the OCS of, according to Mr. Cliff Mbeta, one of the greatest stations in Kenya. And that is not enough. According to Mr. Omari, he has been in the police service for 29 years. Now, with that point of reflection, just before I get to the decision of Titus Ngamau Musila Katitu, a police officer who has been in service for 29 years, who else would have more influence, either on witnesses and or the investigations? And with that point of reflection, allow me to just read paragraph 1, because the Court of Appeal, this is what the Court of Appeal says in the decision of Titus Ngamau Musila Katitu versus Republic. This decision is delivered on 24th April 2020 by Justice William Ouko, may rest in peace, Fatuma Sichale, and William Ouko, I withdraw that, Fatuma Sichale and Ole Kantai. And this is what they say. This is why it is hurting me at this point. The blue code of silence, which we are being told not to talk about, is a common phenomenon spanning across different countries and police cultures in America, Europe, Asia, and even Africa. Kenya is part of Africa. You allow me to just read this. It is the unwritten rule according to which police officers never provide incriminating information about their colleagues, to close ranks in silence, and to cover up knowledge of a fellow officer's wrongdoing with a collective blanket of self-preservation. The offense we are talking about today is the offense of murder. There is no greater offense leading to self-preservation than the offense of murder. We admit that all offenses in Kenya are bailable, but there is no greater need for self-preservation where a police officer, no less than the officer commanding the station, is intended to be likely charged with the offense of murder. A feeling of esprit de corps among officers who by and large depend on each other for their very risky lives as they confront the violent and hostile world of policing and crime. This background is important, and I hope it is also important to us today in our consideration of this appeal, because the police in Kenya, as we shall demonstrate, the three judges are speaking, as we shall demonstrate in this case, as in others before it, has in certain circumstances engaged in the practice of covering up for each other. And the court proceeds to give examples. So that we are saying, when we say that the respondent before you is likely in the act of self-preservation interfere with ongoing investigations, we are not plucking it from the air. There is basis of it. The Court of Appeal has seen it before. Now let us go back to the... Yes, I hope the court will have an opportunity to look at the other parts. Let me go back to the application so that we get back the court to our application, because we may have lost what we are asking. And Mr. Kangai did a good job in referring you to the orders we are seeking. Your Honor, the limited order in prayer number B is that the respondent be remanded at the Langata police station or any other police station within the Republic of Kenya as the investigations may dictate, to enable the applicant conclude investigations. The main primary reason why we are asking to hold him is to enable the applicant, IPOA, complete investigations. Your Honor, now, there are very few questions which are necessary to contextualize. Is Albert Ojwang dead? Yes. Did he die in a police station? Yes. Was the police station Central Police Station in Nairobi? Yes. Is the respondent the officer in charge of that station at the material time? Yes. Has the IO informed you that investigations are ongoing? Yes. His affidavit evidence has not been contradicted or controverted. There is no denial that there are investigations. Coupled with the public interest, even as we presume the respondent innocent, would it be in the interest of the victim? We have seen, just like them from social media, the father of Albert Ojwang confused, running across Nairobi. Is it in his interest as the victim and his family that the respondent should be released on 7,000 or free bond? Because the rights belong to who? Accused persons. And our answer is no. Your Honor, we are at an investigation stage. A decision may, most unlikely, but may still be made that the respondent in the dock is not to be charged. The decision to charge him or not has not been made. We are asking you, because of the complexity of the matter and because of the blue code of the police, which has been judicially noticed by the Court of Appeal of this country, allow us 21 days to complete investigations. If the investigations are complete before the 21 days, Mr. Jibril is a good man, except that he gets a little angered like me sometimes. If we complete these investigations before the 21 days, Mr. Jibril, you can confirm we can come back to court.
Yes, Your Honor, I do confirm.
We pray with you that approximation as per now is that 21 days will do justice not just to us but also the respondent, so that we establish, as his advocates are suggesting, that he was not involved in this matter. As I conclude, Your Honor, there is a deliberate distinction by prioritization of Article 49(1)G and Article 49(1)H. I have always believed that when provisions of the law are put distinctly and separately, they mean different things. So that on the burden and standard of proof, Article 49(1)G, which requires at the first appearance that he be charged or informed of the reason for his detention or to be released, once we have given the reason, we have met the threshold. And that the arguments have been made, and that explains why most of the decisions that have been presented to you are decisions on bail pending trial. So that all we needed, in my view, in my very respectful view, is that the threshold is met once the reason is given and it is satisfactory to the court. The arguments about compelling reasons, arguable reasons, are reasons which are better still placed on arguments for bond pending trial. Let me hit the last point, which is apprehension vis-a-vis likelihood. I have had Mr. Ombeta, who I respect so much because the decision in Dwight Sagarai is one of my best read decisions in this country, tell this court to ignore the bail and bond policy guidelines although he said it in passing, but that was very unfortunate in my view. Because the bail and bond policy guidelines is intended to standardize the application of the law on bail and bond in Kenya. And if I get it right, I think it is clause 4.9 of the bail and bond policy guidelines. The word likelihood is used at least 3 times, so that the likelihood to interfere with investigations is a sufficient ground, even if we were arguing bail pending trial, to deny bail. But on this lower threshold of a balance of probability, where we are asking you to let us complete investigations, the likelihood to interfere with investigations, as my brother will tell you, where there has been uncontroverted evidence of interference with CCTV, that likelihood is very high. And because of the blue code, please hold the respondent for at least 21 days. I submit and I humbly pray. Thank you very much.
Yes, Your Honor, just to finish, I would want to refer you to the affidavit. And this is the reason why I was highlighting earlier about some paragraphs. Let's look at paragraph 11 of the affidavit, where the respondent is alleged to have hired a technician to interfere with the CCTV system at Central Police Station. This is in a bid to tamper and interfere with the investigation. This is a compelling reason. Your Honor, paragraph 13, 13D, in the same affidavit, that after the fatal assault of the deceased, the respondent, together with other persons at Central Police Station, are suspected to have instructed and caused to have made false entries in the police. Paragraph 13D. Yes. That the respondent, together with other persons at Central Police Station, are suspected to have caused to be made false entries in the police records, of course with a view of misleading the investigations. Again, paragraph 17. That the CCTV surveillance system installed at the respondent's office, the respondent's office, had been interfered with the DVR power cable disconnected, and the DVR logs indicated that the operating discs had been changed and formatted. And we have gone further to even indicate the timings. That is on the 8th June 2025 at 7:28:43 hours and 7:32:29 hours. Your Honor, paragraph 18, still on the tampering of the CCTV. Paragraph 20 and 23 on the issue of interference with the police officers. These are compelling reasons. With that said, Your Honor, we still request and we urge you that you grant us the 21 days, which will be sufficient to complete the investigation. That is all from the prosecution.
Your Honor, if it may please you, I'm sorry for coming in late. My name is Julius Juma. Yes, I request that I be placed on record for the family of the deceased. And if you allow me Your Honor.
They'll respond. They are Pandora's box. Just before you continue, I know they want to say about if you're likely to allow them to open their case, they may deal with what we have dealt with, which is very clear. So you can leave it at that. This is court record. And associate. So that they don't open it up.
Sorry. Yes, I was traveling from Homa Bay. I've just arrived. Yes. Thank you. Thank you.
I think now you don't have a chance to respond, but I can assure you that the team by the State Council, the Nora,
Your Honor, I wish to confirm that I have followed the proceedings even while I was traveling.
Okay.
Yes, and I associate myself entirely with the submissions made by the state because I do not want to reopen proceedings again, because once I do that, then my colleagues would want. Therefore, I associate myself with the submissions made by the state, and I will urge the court to do justice to the deceased family. Thank you.
Yes, Your Honor.
What time are we saying? Just 2 p.m. 2 p.m. Yes, Wednesday at 2 p.m.
We are most obliged. Most obliged.
Hakuna mtu anaweza bosha. Si tunaibeba.
You carry this. You're going to the office. You're going to the office. Okay, you carry this. Or you're not attached here.
Chela. Peleka hiyo grey book kwa hiyo ofisi. Waambie kesho waipeleke kwa ofisi yangu.
How are you? I'm Wardon from KTN.
Thank you. This is my boss.
Yeah.
You want to talk to her?
All of them. No? Just on the news, for the names and
My name is not Awi. It's Owi.
J.A.
Yes. Yes, let me see how you write it. That's That's correct. That's right.
And advocate?
Principal prosecution counsel.
Prosecutor.
Oh, prosecutor. Yeah.
Just prosecutor.
Yeah. That's my boss.
Can I say state or just this is just
No right. Yeah, no right. Don't put it.
I don't